Very good evening, my dear friends. Very good evening. We are going to complete our portion in 3 4 episodes, probably. And we are now on the last bit of our discussion on the Negotiable Instruments Act 1881. Three segments of banking are already completed and then left of the NI partly. Now, friends, this particular legislation is essential for running the banking business in India and then all over the world. Without the appropriate law on negotiable instruments being followed, there is no banking system because the entire banking system runs on the negotiable instruments. Checks and bills of exchange and then promissory notes cannot be dispensed with in the trade transactions in spite of the internet banking thereon. This is the most important aspect we have to understand. Then, friends, this Negotiable Instruments Act was enacted in the year 1881, Act 26 of 81, and it was amended in 2002, of course, and then 15 and then 18. It contains, friends, about 148 sections and then 17 chapters. In the examination point of view, of course, chapter 1 deals with the prelims, but chapter 2 is very important on the notes and bills and checks, wherein most important provisions happen to be sections 4, 5, 6, and 7. They deal with promissory notes, bill of exchange, and checks, respectively. Section 4 on promissory notes, 5 on bill of exchange, and then 6 on checks. Then 7 is on the drawer and drawer relationship, and then section 8 is on the holder, and section 9 is holder in due course. And then, of course, there are other aspects also in the examination point of view. You have to cover the basics first. Then, chapter 3, sections 26 to 45A pertains to the parties to notes, bills, and checks. Under chapter 2, of course, sections 4 to 25 are covered with regard to bills and then promissory notes, checks, and then other things thereof. With regard to negotiation, 46 to section 60. Presentment, 61 to 77. And on payment and interest, which is very essential in deciding the issues in the civil courts, 78 to 81. Then the discharge from liability of these particular negotiable instruments, 82 to 90 under chapter 7. Then the notice of dishonor is the most important aspect pertaining to section 91 to 98. And the most important chapter is a noting and protest. That is section 99 to 104A. This is where the notary public's, in fact, role comes into picture. Then, with regard to the time factor, timelines, sections 105 to 107 under chapter 10, then of acceptance and payment for honor 108 to 116, compensation, section 117. Now, another important chapter is rules of special evidence. Special rules of evidence, they are called sections 118 to 122. And then they also contain the presumptions. Then 120 to 122 on estoppel. Then crossing of checks from 123 to 131A. Then bills in sets 132 and 133, international law again. What is the international law governing NI? Because they have got global application. That is from 134 to 137. And lastly, the penalties for dishonor of checks, starting from 138, then the amendments to 138 to 148, wherein the amendments came in 122A, 143A. And with these things, we conclude our discussion on the NI. In this regard, I would like to bring to your notice that we will take up the most important provisions. And then in the examination point of view also, of course. And then we will discuss about them. both knowledge-wise as examination point of view also. Prima facie, friends, we'll have to understand what is this negotiable instrument. So, the history of negotiable instruments takes back to the law merchant. The source is in law merchant and codified in Bill of Exchange Act 1882 of England, and then the Checks Act 1957. Friends, the meaning of negotiable is that transferable instrument is a document, a written document creating rights. So, negotiable instrument means a transferable instrument in writing, creating rights to the holder. So, you can say, as per the definition, the negotiable instrument is a document which entitles a person to a sum of money and which is transferable from one person to another person by mere delivery or by endorsement and delivery. Mere delivery also, or endorsement and delivery. That means somebody else in whose name it is endorsed will get this particular amount. In fact, Section 13 contains the necessary provisions in this regard, which says a negotiable instrument means a promissory note, a bill of exchange, and a check payable either to order or bearer. And then, prima facie, there are three explanations given that a promissory note, bill of exchange, or check is payable to order which is expressed to be so payable, or which is expressed to be payable to a particular person, and does not contain words prohibiting transfer or indicating an intention that it shall not be transferable. Explanation 2. A promissory note, bill of exchange, or check is payable to bearer which is expressed to be so payable, or on which the only or last endorsement is an endorsement in blank. And then explanation 3. Where a promissory note, bill of exchange, or check, either originally or by endorsement, is expressed to be payable to the order of a specified person and not to him or his order, it is nevertheless payable to him or his order at his option. So it further says, subsection 2 of 13, a negotiable instrument may be made payable to two or more pays jointly, or it may be paid payable in the alternative to one of two, or one or some of several pays. So here you understand that a negotiable instrument means either it would be a promissory note, a bill of exchange, or a check, and anything which comes under the characteristics of these three alone would be called a negotiable instrument, otherwise no. So any instrument which satisfies the conditions as stated under various provisions relating to checks, relating to bill of exchange, relating to promissory notes will have to be taken into account for calling it. As for example, the share warrant, railway receipts, etc., which come under the category of bills of exchange, then you call them as a negotiable instrument. Friends, Willis, a great author, has written a book called Law of Negotiable Securities. And he defined the negotiable instrument as the negotiable instrument is one, the property in which is acquired by anyone who takes it bona fide and for value. That means the negotiable instrument must be obtained for consideration, right? And if there is any fraud in transferring the NI, negotiable instrument, the party, the recipient, should not know about it. Otherwise, he is not entitled for getting the benefit of that. So the definition says it is one the property in which is acquired by anyone who takes it bona fide and for value, notwithstanding any defect of title in the person from whom he took it. So here section 9 speaks of the holder in due course. So basically, holder in due course is an exception to the doctrine nemo dat quod non habet. A person cannot convey better title more than what he has. But here is a case where the transferor's title is defective, but still it is acquired for value and consideration and in bona fide, then it will stand good. So Thomas, another author of Commerce, Its Theory and Practice, he also defined a negotiable instrument as one which is by a legally recognized custom of trade or by law, transferable by delivery, this is the most important thing, or by endorsement, given to somebody else with endorsement, and delivery. Of course, delivery is must, endorsement is never. First, without notice to the party liable in such a way that you need not give notice to the original drawer. The holder of it for the time being may sue upon it in his own name. The property in it passes to a bona fide transferee for value, free of equities, and free from any defects in the title of the person from whom he obtained it. Thus, a person taking an instrument, a negotiable instrument, in bona fide and for value, is called holder in due course, and friends, he will get a good title, even though the title of the transferor may be defective. So, the negotiable instrument, friends, constitutes an exception to the maxim, as I told you, nemo dat quod non habet. If a person cannot convey a better title more than what he has. If a note is taken from a thief in good faith for in fact, for any consideration, then it is a valid transaction. Consideration need not be adequate, it can be past, present, and future under the provisions of consideration, wherein section 2D comes into picture of the Indian Contract Act. So here is a case we will discuss in this connection. Raffle versus the Bank of England, 1858. Some banknotes of the Bank of England were stolen in a robbery. Then the bank notified them, and then they were all distributed, the numbers. However, the plaintiff happened to be a money changer, and then he was in Paris. He also received such a list, and a year later, some person came to the plaintiff and then exchanged it. Unfortunately, this stolen note was found, and then the banker refused to make the payment, saying, "We have already notified." But the court of law said he received it in good faith. It is 1 year later, so he took it value, and for consideration, he was entitled for payment. He might be negligent, but he was not dishonest. What is the basic principle here? He might be negligent, but not dishonest. So that is taking for value in bona fide. This is the most important provision. So friends, this is the concept of negotiable instruments. And then, in fact, this particular person was declared as entitled for payment, and the court of law ultimately, English courts, allowed the plaintiff, the money changer, to receive the money. This is Raffle versus the Bank of England. The matter went against the Bank of England. So friends, with this background, I conclude my discussion on the basics, definition, meaning of negotiable instrument. Negotiable instrument means only under, as I told you, section 13 with explanation, only a promissory note, bill of exchange, and check. And then the promissory notes are described under section 4 of the NI Act. Bill of exchange is discussed under section 5, and the checks are discussed under section 6, and the overall application of principles for all the three were discussed under section 7. So when a question comes on the negotiable instruments in general, explain what is a negotiable instrument. You have to say it's a transferable instrument, and then you have to give the features, and then you have to say the two definitions. You have to write, I have already given, and the Raffles case also, that it stands as an exception to the doctrine of nemo dat quod non habet, that is the holder in due course, section 9. And then you have to say the features are concerned. What are the features stated under section 3 for the promissory notes, 4 for bill of exchange, and 5 for checks, and as section 7 covering all the three would be applicable for ultimately the characteristics, and any instrument which is nearer to the characteristics of any of these three instruments under these provisions would be called as a negotiable instrument. like the bill of lading, the railway receipt, and so on and so forth, which could be taken as the bill of exchange. So, friends, with this background, I conclude my discussion on the definition, meaning, and then analysis of this particular subject of negotiable instrument. In our future sessions, I will deal independently, one by one, the promissory notes, the bill of exchange, and then checks. Then I will also cover the actual, the particular subject matter pertaining to holder and holder in due course. Then the rules of evidence, the international law, and then noting and protest. These are all the important aspects of negotiable instruments, and rest of the things I have already told you. You please read the beautiful book, Varshney for banking, and then Avatar Singh for negotiable instruments, apart from Tannen. So, and Basham and Adiga for negotiable instruments as a reference book. I have already given is necessary. In fact, guidelines on that earlier. I have circulated some material also. Based on that, please make out your answers, and then you make out a very good, presentation of this particular subject matter. So we'll meet again with the features of the promissory notes, followed by the checks and then the bill of exchange. Bill of exchange and the checks, of course, because check is nothing but the extension of bill of exchange. That's the reason why we'll deal with then second bill of exchange, the comparison, and then the checks also. Check is also bill of exchange, in fact, but the characteristic of check is different because it is pertaining to banking, whereas the bill of exchange could be drawn by any even two individuals in between. So this is what we are going to study further, my dear friends, and then I look forward to meet you again. Thank you very much, and then good night. Bye bye. Thank you.